It's in the afternoon now.
Yeah, sorry about that.
Quite.
So we're not behind schedule too terribly.
Good morning, Your Honors. I'm Ken Missouri here for the appellant Progressive. I'd like to reserve 5 minutes.
Okay, you
For
got
the vote, and may it please the court. We're here today on a PIP suit that involves a dispute that's been come to be known as a billed amount dispute. And there's a reason it's called a billed amount dispute, because what happens in a billed amount dispute, what happened in this case is a provider such as Back on Track, a chiropractic clinic, issues bills to the PIP insurer for treatment of an insured, and the insurer, in this case Progressive, accepts the charges that are issued in full, doesn't reduce them, doesn't deny them, doesn't take any issue with them, and pays 80%, which is the PIP coverage.
And that's for the policy.
For the policy and for the PIP statute, because 1A is the coverage mandate, that's non-disclaimable, fundamental, 80% of all reasonable expenses that are also compensable. So you ask yourself on the face of it, where's the controversy here? They build this amount.
The controversy, right, comes from the Geico cases.
Correct, and I was going to frame that.
We can kind of get there because you all have favored us with an exhaustive record and extensive briefing, and we've read all of it.
I was going to get right to the controversy. So here's the controversy. The controversy is their position is that merely, in this case Progressive, merely by adopting what's known as the scheduled maximum charges as a cap, as a maximum limitation on the amount of reasonable medical expenses, Progressive and any other insurer that does it, thereby commits itself to paying all medical services.
The cap becomes the floor, essentially.
That's right, essentially. You have to pay all medical services at the cap. I'm sorry, please.
And the Supreme Court told us in the State Farm MRI case that it's a cap, not a floor, right?
100% correct, Your Honor.
And the Geico cases, and I'm going to ask your opponent some of these questions the other way, but the Geico cases say that 5A5, I think I've got that right, says when an insurer receives a bill for less than the allowable amount under 627-736 5A now 1, the insurer may pay the amount of the bill, right? And then Geico's policy has language in it to the effect that when we receive a bill for that's less than the allowable amount, we'll pay the full amount of the bill, something like that.
Shall pay.
And the Progressive policy is a little bit different, isn't it?
It is. It doesn't contain any language like that.
In fact, it says we will not pay more than the fee schedules. Correct. Which your side of this case is going to say that's a lot like State Farm's and a lot not like Geico's, right?
Essentially, yes.
So that brings us to what I think might be the key question here, which is the way the courts, the 5th DCA and now the 4th in the Geico cases has interpreted that statute, that subsection of 627-736 is that it means when you get a BA, you still have to pay 100%. And I struggle with that a little bit because to me, MATA does not mean shall generally, although it can. The 4th District told us that a few years ago. They turned out to be wrong, but they had some law under it. So help me out with that part of it.
Yes, Your Honor. That's addressed in our brief. And let me explain to you what our position is on that and how I believe in my heart of hearts, working on this issue for 2 years, how this statute is supposed to be interpreted. Okay. And since
only 2 years,
probably longer, I'm estimating. Since MRI Associates 2, which affirmed this court came out, our interpretation of that provision has been confirmed. I would submit to you, okay? Because MRI Associates 2, if I can take a step back, says that the fee schedule is a floor, is a ceiling, not a floor. It's a ceiling, is a cap, and it's not an exclusive payment methodology. So the insurer like Progressive can still use the reasonableness methodology. So with that in place, okay, let's look at 5A5. And it's the last sentence that says if the charge is less than the amount payable under the scheduled maximum charges, the insurer can pay the amount of the charge. That is a single sentence in subparagraph 5A5 of the PIP statute, which follows paragraph or subsection 1A, which said, as we know in Allstate versus orthopedic specialists, sets forth the non-disclaimable fundamental mandate, 80% of all reasonable expenses. That is the fundamental mandate and the basis of PIP coverage. So you start with 1A and you go to 5A, okay, which is subsumed within that mandate. It is subject to and subsumed within 1A's mandate.
And I think I can cut to the chase for you on 5A1, right? Your argument presumably is that the provider's charge shall be reasonable. That's what it says. And the provider's charge and the insurer is required to pay what's reasonable. And the provider's charge may not exceed the amount of that provider customarily charges. So here, if the provider charges less than the allowable amount under the fee schedule under either category, whether it's between 80 and 100 or under 80, then it's only reasonable. The only reasonable payment would be the amount charged, and that you use that factor, right?
Right. We accept it in full and
paid your 80%.
Charge reasonable full and pay 80%. I was working up to the 5A5. So if you look at 5A1, and again, this is in our brief, it talks about an insurer paying such charges, or probably 5A or 5A1. So just because it doesn't say there in the first part of 5A, pay 80% of such charges, doesn't convert it to 100% mandate. The same is true with subsection 5. When it says may pay the amount of the charge submitted, that means 80% pursuant to the coverage mandate under 1A.
Well, I think that language could be clearer, and it would be a lot nicer if the legislature said may pay 80% or shall pay 100 or whatever it is the legislature wanted to do, but they didn't. So this is what we have. I want to ask you a couple other questions. The trial judge at the time he decided this case was confronted with precedent that I don't think would be characterized fairly as a model of clarity. He had the Geico cases, he had the Revival case with Allstate's policy language, and he had the State Farm MRI case from our court that the Supreme Court ultimately, but after the trial judge ruled, approved, but for slightly different reasons than our court supplied in its opinion. So the trial judge relied on the 5th DCA, on Irizarry, which has subsequently become the hands-on case and Moransky, and they all followed that line.
Absolutely.
And so was the trial judge wrong on that day before he had the benefit of the Supreme Court's case? And that's one question, and I know you're gonna have a big long answer for that. And, or maybe not. And the other question I have for you, which is completely distinct, and I'm gonna try to shut up and let you talk for a minute, is your opponent has taken the position that in your affirmative defenses, you allege that you had paid at the fee schedule, and now you're stopped to say, I don't have, or effectively, I think that's what he's saying, that effectively you can't disclaim paying at the fee schedule, at least. So if you could address those points sequentially, I'll try to be quiet and listen.
Your Honor, we submit to you the trial court was wrong because the trial court was in with underneath the 2nd DCA and should have followed MRI Associates 2. I'm sorry, MRI Associates 1 from this court, which was clear on the face of it that the fee schedule or the schedule maximum charges in their fact-dependent methodology with the factors in 5A are not mutually exclusive payment methodologies under the post-2012 version of the PIP statute. We were in this district, the trial judge should have followed that law. Yes, the Supreme Court affirmed that ruling on a little bit of a different analysis, which we believe is correct and was totally consistent with what we've argued throughout this case from the trial court. So it's been borne out that yes, the trial court was wrong for not following MRI Associates 1, made exceedingly clear with MRI Associates 2. So
I'm sorry, because I gave you you answered my question on the first part, and I gave you a second question, but before you answer that, neither of you has filed this, but anybody who's reading the Florida Law Weekly has seen it. The 3rd DCA has the same case, the Calumna case, I believe, with your insurer. I think you all were there together. Deja vu all over again today. The 3rd DCA punted it back to the trial court so that they could consider the decision in the light of the Supreme Court's opinion in State Farm. The 3rd was whoever the trial judge was, and the 3rd DCA was situated the same or better as Judge Moody was here because they didn't have any precedent. They didn't have the fifth. He wasn't, you know, he had to choose between the second and the fourth, or the fifth, the fourth and fifth. So what, should we punt?
Please don't. Please don't. And I mean that in all sincerity. This is a huge issue across the state for insurers. The third DCA is punted. We're about to file, it's not in the record, it can be an officer of the court. We're filing our memorandum of law in that court. It's my understanding we're not even going to get a hearing until November or December this year based on the trial court's docket. This issue has to really be decided. And that's,
if we do what you want us to do we have to certify conflict with Irizarry, Moransky, and hands-on?
I think that would be prudent for one reason. The new affinity case that came out, that was the subject of their notice of supplemental authority, which I can address too. I think without that new affinity case, which was post-MRI Associates 2, which I think the court just missed that decision, then I would say maybe not, because if you because your ruling will be the one post-MRI Associates 2.
Let me give you the counterpoint though, on why I don't think we necessarily, if we adopted your argument. The GEICO policy is essentially the mirror image polar opposite in terms of what we will pay. We will pay 100% of a BA charge, and we will pay to the fee schedules. Progressive's policy is we will not pay more than the fee schedules, and that could be a meaningful distinction. So do you still think we have to certify conflict?
Yes, Sean, because here's the problem, and if you ask Mr. Randall, he will tell you this. He will say that Moransky, hands-on, Irizarry are all based on the PIP statute, the interpretation of the PIP statute, not the policy, and that's what we're going to hear.
Okay, so he's going to tell us about that, and I'm sorry
so
to keep jumping in on you. Please address the affirmative defense issue.
Yeah, absolutely, Your Honor. First of all, it wasn't argued under estoppel, and it could never be estoppel. To have an estoppel.
That was probably a bad choice of words on my part, well, but you know what he's arguing.
Let me say this, you're grappling for something to call it because there's no legal doctrine that it's under. As I said in the brief, or as you said in the brief, it's a gotcha. Well, you pled this as an affirmative defense and you're somehow stuck to it.
Well, part of what you argued in your brief, though, was that this lawsuit was based on a pretty big patient ledger. So we have a big stack of EOBs attached to your guys' affidavit. And my understanding of your argument, correct me if I'm wrong, was that by the time you got to this hearing on this motion, which was going to be dispositive, you, one way or the other, had taken out the NPPR cases and whatever else they had moved on. And that your affirmative defense, to the extent that affirmative defense was we paid at the fee schedule, it pertained to those claims, not the BA charges. That's
exactly right. So let me take, you got it. Let me frame it a little more finer point. So they sent a demand letter asking for additional PIP benefits on every single charge in the case. They filed a lawsuit asking for more PIP benefits on every single charge in the case.
And their complaint, the operative allegations are you underpaid and or you misapplied the deductible. So you're responding to a wholesale collection of alternative theories on a stack of bills.
You underpaid Progressive, they're alleging, every single service from May 15, 2015 through July 21st, 2015, some of which the charges were greater than the scheduled maximum charges and therefore reduced by Progressive to the scheduled maximum charges. And keep in mind, it was fluid, there's always new issues arising. You know, back at the time, it was viewed that was going to be the issue.
The complaint was filed in 2015, which was before the deductible decision came out, and it appears to have been at least trying to capture that possibility.
Right, and that's when the fee schedule was still being litigated too. You know, reductions pursuant to the fee schedule.
I think 2015, the Allstate case hadn't come down yet.
You got about a minute before you get to your 5
minute. Okay. Well, I can look at that. I think Irizarry hadn't come out yet. That's what really tripped off the billed amount issue, if you will. That's when it all got started. So, you know, Progressive's defense attorney looks at this and says it looks like a scheduled maximum charges, you know, reduction case, and raises that affirmative defense as would be malpractice not to. That's what's at issue here. They file an early motion for summary judgment, making that issue on those particular charges, which are not the billed amount charges. And then the plaintiff changes its position, withdraws all those arguments, withdraws the NPP argument, and focuses on the billed amount issue, which the affirmative defense saying, you know, we paid pursuant schedule has no application to. So it was never argued, it was never ruled upon. It became irrelevant. There is no estoppel, it's impossible. It's just like if you raise a seatbelt defense in an auto case, and it turns out that the person was wearing your seatbelt and the defense goes away. There's no
You're all right,
prejudice.
your 5 minutes, you want to say?
If I can just finish, yes, thank you for
Go ahead.
it doesn't, the fact that you raise an affirmative defense that you end up not using or it's not being relevant doesn't bind you to that affirmative defense. There's zero case law that says that. That's why they cite no case law in support of that argument. And that's why you can't even figure out what to call it. It's not an estoppel because you're
gonna sit down, but I want to ask you one other question I might need to address in the rebuttal. The one thing about Progressive's policy that's troublesome here in the context of what we discussed is that it says we will determine to be unreasonable any charges that exceed blah, blah, blah. And the maximum charge is set forth in section 6273658 2A through F, which is actually the 2012 version of the statute, not the 5A1 statute. Does that change or otherwise undermine your reliance on MRI2? And you can sit down and answer it.
I can answer real quickly and say no, that's a Scrivener's error. The factors are listed in there, the same factors, so it does not change the analysis.
All right, you can answer the question. You got 4 minutes left.
Thank you.
All right, you're fine.
May it please the court, Matthew Emanuel on behalf of the appellee, Back on Track, LLC. Good morning. I want to first start with the discussion of the applicability of MRI Associates. The Supreme Court case affirming this court's prior ruling concerning the policy language of State Farm.
You're talking about the State Farm MRI case.
Correct. And I want to start back with this court's initial ruling that ultimately went to the Florida Supreme Court. And this court specifically framed the issue as, or the trial court did, as whether the policy language that State Farm had, a rather unique policy language, which stated a reasonable charge was defined as all the factors under section 5A and the 5A1 fee schedules, whether that was sufficient under the new 5A5 to provide notice that of its intention to limit payments to those fee schedules. And the court in footnote, this court in footnote 1 of its decision noted that the actual payment amounts and whether they were proper pursuant to the fee schedules was not before, was outside the scope.
Well, BA wasn't an issue in State Farm. The question is the reasoning, which is we don't have two distinct methodologies. The illegal hybrid thing that is, I think, fleshed out in Moransky and that is behind a good bit of your argument in the other two cases. You either have to pay fee schedules, in which case you got to pay fee schedules, or you don't. You have to pay under the factors of 5A1 and you get a jury trial. That's really what's going on in the State Farm MRI case. And what the Supreme Court said once and for all, because it hadn't been said before, is in the post-2012 statute, the fee schedules are a cap, not a floor, and there is only one, for lack of a better term, methodology, and it is that you pay 80% of reasonable. And when you decide what is reasonable, you can look at the fee schedules and you can also look at the factors in 5A. So that's why we're here. And that's the argument that Progressive is making with the benefit of the Supreme Court's having said so. So we don't need to talk about whether State Farm could use the fee schedules or not. We know the answer to that. The question is, does the holding of State Farm by this court and ultimately the Supreme Court with regard to cap, not a floor, and no more hybrid, because that was the big argument that was made to this court was illegal hybrid can't do it. If your policy is ambiguous on whether you've elected, you have to pay 80% of reasonable, which is a lot closer to what was billed about fee schedule, et cetera. Here, we now have the benefit of knowing that in determining reasonableness, an insurer can consult not only the fee schedules, but also the factors in 5A1, which include the provider's usual and customary charge, which here was less than the fee schedule. So why is it unreasonable to pay that?
Because, Your Honor, there's this distinction between generally having the ability to pay under different methodologies and what an insurance company could do. And here, we're not dealing in the broad sense of, well, what could Progressive do if it wanted to pay these bills? It is what Progressive already did. How did they pay?
Well, they paid 80% of what was billed. We agree to that, right?
Correct.
And how is that not? How does that not?
Well,
look, let me finish. How is that not paying based on the factors in 5A, specifically what the provider customarily charges? What insurer in the right mind would pay more than what the provider customarily charges? Isn't that per se reasonable?
Your Honor, the issue of what the provider charges is not essentially relevant in what we're looking at here.
It absolutely is.
Well, the issue is Progressive's payments, because you can pay under the fee schedules and you can use.
Well, Progressive, come on, we agree. Everybody knows Progressive has to pay reasonable. That's what the PIP statute says. That's what the Supreme Court says. Nobody argues.
And there's and just like the different methodologies are not mutually exclusive, nothing prohibits an insurance company from saying we're just going to pay in accordance with the fee schedule and process all the bills.
But that's not what Progressive said. What Progressive said is we're not going to pay more than.
No,
it will always be unreasonable.
It's not about their policy. This is about how the initial payments and all the explanations of review that were in the record demonstrated they put notice of their payments under the fee schedule. That's it, and specifically to the insured, to the claimant, that because they're paid under the fee schedule, you're not allowed to balance bill essentially, which is what's in the statute. So that's how the claims were initially paid. Then in their affirmative defense, they don't just say they paid.
You're saying that the BA claim, the claims that were billed below the allowable amount, either under 80 or under 100, that their EOBs say we're not going to balance bill.
Well, you said so it's how they made it.
Is that what they say or not?
It's what it said. There's a notice of fee schedule. It's cited. I put a footnote in the brief of the exact language, Your Honor, and I don't want to waste time reading it, but essentially just putting them on notice that the fee schedules are being used to pay those bills. And then in this case, they took the position not that they limited payments of the fee schedule. Their specific affirmative defense in this case was that the dates of service submitted to the defendant were paid in full in accordance with the underlying policy of insurance and Florida's
and there's a comment in there, so we don't know what they were defending on, and your opponents already said, and I don't disagree with them. You had a bunch of claims in here that you were the way your complaint was pled could have been in 2015 would have been, if it had gone the wrong way for you all, or if it had gone the right way for you all in Allstate Orthopedic Specialists, would have been fee schedule claims. You would have been arguing that Progressive wasn't allowed to pay at fee schedule. It was supposed to be paying 80% bill on those claims.
I'm not here to argue what would have happened if different rulings came out of court.
But the way you pled the case originally was you underpaid or because you shouldn't have used a fee schedule or you misapplied the deductible or you just underpaid. You didn't parse out which of your bills were MPPR problems, which were they shouldn't have paid on work comp because it was participating physicians or any of the rest of it. And what you wound up with were a collection of bills that were BA. And you haven't answered my question, and you can tell me if it's in the record. Are you saying that the EOBs for those particular claims indicated that they wouldn't be balance billed? And if they did, why is that a problem?
Because the EOB, they stated, please be aware that pursuant to Florida Statute 627, 736, 582, and 5, if an insurer elects to pay pursuant to the fee schedules found in paragraph 2, then pursuant to paragraph 5.
If an insurer pays pursuant to the fee schedule.
Correct, so they took this is counsel's discussion of we accepted it, and there's no record evidence whatsoever of anything in it. There's no deposition, there's no affidavit, there's nothing filed. There's nothing filed that states that they paid any other way than according to 80% of the participating physician fee schedule.
So you don't think the affidavit that Progressive filed of its claims adjuster with the 2-foot stack of EOBs under it, that doesn't say how they paid the bills?
It does not. It absolutely does not. There is no statement in the record.
But you agree the whole problem. I mean, there's not a dispute on this. Progressive paid a collection of bills at 80% of the amount charged.
By applying the fee schedules, and when you
but wait, you were talking about the bills that were paid at 80% of billed.
There's no distinction because Progressive took the position that they paid pursuant to the fee schedules. So when you're paying.
So this hinges your argument right now hinges entirely on that affirmative defense, that they took the position that they paid pursuant to the fee schedules, and now you're saying no, they didn't. They paid at 80% of the billed amount.
I don't believe you're characterizing what I'm saying correctly, Your Honor. What I'm stating is the party's position in the case where the bills that were submitted, without exception, were the fee schedule was applied to those bills. So under section 5A1, those are the fee schedules that Progressive was using to remit payment to my client. And so since you're paying under the methodology, this is not talking about whether we elect to pay or we limited to pay. Once you choose to pay under those fee schedules, the sections 5A2 through 5A5, that is what governs how the proper payment should be made. And that is why sections 5A5's third sentence, which deals with charges that are submitted below the fee schedule, that's why that is the statutory analysis that is before this court. It is not broadly whether or not Progressive could do something in this case, it is how they actually paid, and that is what the record shows. So if you're paying under 5A1, 80% of the participating physician's fee schedule and plaintiff's charges that fall below the fee schedule amount, what is the proper payment? So in this case, the Irizarry court, and then they confirmed and clarified hands-on chiropractic, Moransky, they specifically interpreted the statute. It's not about the policy language of GEICO versus Progressive. What the issue is under the statutory interpretation, when the charge is submitted less than the fee schedule.
Well, hands-on, which purported to clarify, back up to Irizarry a little bit, says that nothing in GEICO's policy or the statute allows it to pay at 80% of bill. And it also relies on, it characterizes the way that GEICO paid as an unauthorized hybrid payment. Looking at it through the lens of you have to go one or the other, you can't evaluate reasonableness in the context of 5A as well as 5A1, the fee schedules in 5A1. And that's a distinction.
I don't believe that's not what I believe if you read the first paragraph of that decision, it says when insurer chooses to reimburse under the fee schedule. So this is, again, they're not talking broadly about hypothetically how you could pay. When the insurer chooses to pay the fee schedule, what's the proper payment? So when they're addressing the improper payment in the case of GEICO, they're discussing when you're under 5A1. Is it
your position that Progressive chose to pay the BA charges under the fee schedule?
The pled defense, right, position of Progressive and how they actually remitted their payments was according to the fee schedule. And it was specific. This is not a case of Progressive saying we paid certain bills certain ways. The record is devoid of anything that counsel is relying on to make that argument.
So you're saying the Progressive purported to pay everything at the fee schedule. Then why are we here?
I'm sorry?
If Progressive paid at 80% and 200% of PPS or work comp, then why are we here?
Because that is not what the actual payments were.
The actual payments are 80% of bills.
Yeah, the payments were not made. They were not made at 80% of the fee schedule, because if they paid under section 5A1 and then the provider since charged less than those allowable amounts, then the statute tells you specifically how payments are being made. And when counsel and the issue is what does that third sentence of 5A5 mean? And even in Murray Associates, Supreme Court noted that the supremacy of text canon is perhaps most important, that the legislature means what it says. So when you read that,
and when it uses the term may, it usually means can but don't have to.
Correct, because there's an option. It's not saying that you always have to pay the full amount of charge submitted. You can pay the schedule rate 80%.
Well, it doesn't say that either. It just says may pay the full amount of the charge. Period.
Well, but it's specifically referencing subsection. It's specifically referencing subsection 5A1, which is 80% of the fee schedule. So it's governing how payments are made when you're choosing to pay according to those fee schedules. Otherwise, that third sentence has no effect around it, because if the insurer, like Progressive in this case, can simply pay 80% of the submitted charge, even when it's paying according to the fee schedules in 5A1. Then that's.
But it's still what it says. If the provider submits charge for an amount less than the allowable amount under subparagraph 1, which is the fee schedule paragraph, the insurer may pay the amount of the charge submitted. And why isn't it a fair reading of this, given the context of the entire statute, the mandate of which is pay 80% of reasonable, to say if the provider submits a charge for an amount less than the amount allowed under the fee schedules, the insurer may pay the amount of the charge, or, because it doesn't say shall, may pay a reasonable amount, like the charge that is what the provider customarily charges, which is what the bill was.
But the 4th and 5th DCA address this specifically, and the interpretation of that section to add in the 80% of the amount submitted, which is not what the statute actually says, any interpretation of that would render that section superfluous. Because common sense dictates, as those courts noted, that an insurance company is never going to pay the charge in full 100% if they could, at their option, pay 80%.
So let me take you to the other place. Just assume that we might go with your opponent's position here? Do we have to certify conflict? And if your answer to that is yes, tell me why Irizarry et al. Are not distinguishable on the basis of GEICO's policy language.
Well, you would be certifying conflict based on the specific interpretation of section 5A5 that third sentence, which was not only reviewed by just one or two panels in the fifth, but multiple panels in the fifth and fourth. So there was in total 8 different judges from the 50 CA, 9 judges from the fourth.
And to pick up on your lead there, since State Farm MRI came out, we've had several trial courts, and your opponent favored us with the decisions in the appendix to his reply brief, who have reached the opposite conclusion on policy language similar to progressives. Why shouldn't we follow those cases? I know they're not binding, but they are all 3 or 4 different judges with the benefit of the guidance that the Supreme Court has given us, reasoning and arriving at a different conclusion with the same arguments that you're making here. Why shouldn't we follow those cases?
Well, I can tell you, since I was counsel to those cases, specifically against State Farm, that those are dealing with specifically State Farm. So there's no other, the counsel did not provide decisions from other insurance companies, and if the court, I could have provided supplemental authority as well of county court judges, but they're not.
Do you have any for progressive where the trial judge post State Farm went the other way?
Yes, sir.
Have you filed that?
I have not filed it, but what I did file was the 50 CA's reaffirmance of their hands-on chiropractic decision on March 25th, 2022 in their definitive case. So that's from the 5th district.
So last question for you,
yes.
Maybe. Should we punt like the third did in Kalamna?
No, Your Honor, because in that case there was a discrepancy with how certain payments were made, and there was I guess the court wasn't sure based on the record below. Specifically what payments were made for the codes and what the court could consider in light of MRI associates. Here, the record is very clear. The record is simply they took the position that they paid specifically 80% of the participating additional fee scales for Medicare Part B. And so the arguments concerning the bill of issue when charges are below the fee schedule, that is all that's before the court, and there's nothing else in the record that this court can really look at or rely on to show that there was any sort of disagreement between the parties or there was any issue of material fact. In fact, the parties stipulated that there were not. So if there was going to be some other type of payment methodology, or there was anything else that this court can look at to say, okay, well, we should go and reverse on that basis, it's not part of the record. So we're looking strictly at when the insurance company pays under 5A1, according to those fee schedules, what is the proper payment?
But you keep saying that they paid under 5A1, and what they paid under was 5A.
That's not what the record shows, Your Honor.
And you're relying on their affirmative defense for that?
Yes, Your Honor, because that is the only thing that articulates how their payments were made in the entirety of the underlying case. They can't abandon that defense.
You don't think the EOB that shows 80% of the amount billed is record evidence?
It confirms exactly what we're saying here today.
But then you're trying to have both ways. They either paid at 80% of bill less than the fee schedule amount.
They paid by applying the fee schedules to the charges, and that's not there is no record evidence of any other type of methodology, no factors considered, no factual basis. No other various factors in Section 5A. None of that there's no evidence whatsoever that was considered. And counsel, just because those options are available, does not mean that counsel can assert here in this case that they did that.
You're down to less than 3 minutes. So if there's something else you need to add, now's your chance.
So our position, Your Honor, is that the narrow issue that's before this court is simply what are the proper payments made. Or what should proper payments be when you're looking strictly at sections 5A1, and then as the MRI Associates noted, the rest of the statutory provisions that govern what is proper payments, which are contained in 5A2 through 5A5. So
well, there is no 5A2 anymore.
No,
right? It's 5A1 A through F.
No, 5A2 through 5 are the additional provisions of the statute that dictate how the payments of the fee schedule are being made. Those are the rest of the statutory provisions that deal with the fee schedule payments. The fee schedules are articulated in section 5A1, yes, but 5A2 through 5 are how those are applied.
So that 5A2 tells us about which Medicare schedule and all that and all that. So the 2007 limitation, it has nothing to do with whether the initial determination of reasonableness under 5A, which we now know is only one evaluation, not two mutually exclusive methodologies.
Correct, Your Honor, but we're still dealing with when Progressive takes the position that that's when they actually pay pursuant to the fee schedules, and when they take the position that's how they paid, then all we're doing here is analyzing under the statutory provisions were those payments proper. And the 4th and 5th DCA, there's 17 different judges have confirmed what the interpretation of that last sentence of section 585 means. So for this court to overturn the trial court, it would have certified conflict that the 4th and 5th DCAs and Judge Byron in the Middle District of
we're not in conflict with the federal judge.
Well, just their interpretations of and their analysis of how that last sentence is applied and what it means were wrong. So if the court is going to overturn the trial court, that's that there has to be.
So you don't think Geico's policy language is relevant at all?
It was relevant to the extent that whether they always have to pay the charges submitted less than 80% of the fee schedule, always have to pay it 100%, but because they put the word shall in there, but otherwise it's optional. The insurance company, Progressive, doesn't have to. The other option is they can simply just pay 80% of those fee schedules, but they could. That last sentence is in there for a purpose, and that purpose is to prevent Progressive from ever paying more than the submitted charge by the provider. So since it's less than 80%, these are the providers, Your Honor, who are the lowest charging providers in the community. So the benefit is everyone here is winning. We have Progressive is not paying 80% of the fee schedule for that charge that's submitted so low, it's less than 80%.
10 seconds.
And then the insurer gets reduced co-payment, the provider gets paid. So there is sound logic in those courts' interpretation of how those sections apply.
That's it. You're out of time. Perfect. All right. You got 4 minutes left.
I'll be talking fast.
I hope so. I'll be watching the clock.
Thank you, sir. We'll do our parts. Okay, so it would be, Your Honor, we would love nothing more than be able to say it here, stand here and say this is all a Geico policy problem. I will grant you that I think it's very clear that the problematic language in Geico's policy started this whole ball rolling with Irizarry and the way it worked itself up, the way it has now. But let's take a look at hands-on, and I want to tell you why this is so important that this be addressed. And if you agree with us to certify, that he referenced the initial holding, and let's read that. We hold that when an insurer chooses to reimburse according to scheduled rates, it must pay 80% of 200% of the statutorily adopted applicable fee schedule. That sentence is in direct conflict with MRI Associates 2. Here's the second sentence, which is why I'm reading this to you. There is nothing in the statutory scheme that permits a PIP insurer to limit reimbursements to 80% of billed amount. So they are interpreting
so your
the statutory
position
scheme.
that is in direct conflict with the way that the Supreme Court interpreted 5A as being part of a unified approach to reasonableness in conjunction with the fee schedule, that all the factors A and A1, and that nothing in the statutory scheme permit that. Then you look back at the statute that says one of the factors you can consider is the charge customarily charged by that provider.
Absolutely, and there's a catch-all there too. But what are we supposed to do? We accepted 100% of their charges. What do they want us to say? We raise a reasonableness flag and say thank you for your reasonable charge. I mean,
Understood.
So there's nothing to be done there. But the reason I read that to you is the focus is on the statutory scheme. We need this cleaned up.
I appreciate you.
And it conflicts with MRI Associates too. And so we need this fixed.
Well, the Supreme Court will tell you whether it conflicts with their case.
We think it does, clearly. We would respectfully submit to you, and if we get to the Supreme Court.
Well, and the Fifth didn't have the benefit of MRI when it wrote hands on.
I would agree. Neither did the Fourth and Moransky, neither did the federal court provide. And Your Honor, just to I'll address this balance bill issue. There's no issue with balance bill in here.
Well, I know there isn't, but the question that I asked your opponent, and I can't get to the right answer, and maybe I'm being obtuse. If Progressive purported on the EOBs for these VA charges to be paying pursuant to the fee schedule, I think you've got something to explain.
We did. I'm baffled by it too. What's happening here?
Can you cite me to just give me an example of one of the VA EOBs? I was hoping you were doing that.
I can. They're in the. Yes, it's in my brief. I don't have that.
Okay, so you've got a cite in your brief to a record site to a specific EOB that was paid at VA, and it's going to show me that it doesn't say it was billed. It was reimbursed pursuant to the fee schedule.
Yes, Your Honors. In our reply brief, where we're addressing the arguments on the affirmative defense, there's a footnote where it talks about where the opposite of what you're saying, where the charges that were greater than the schedule are. They're in the, you know, it has the record sites for the EOBs. I think it's the last footnote.
And I'm gonna look at those and it's not gonna say we paid you pursuant to the fee schedule.
No, there's a reason code for each charge, and there will not be a reason code for the fee schedule next to the charges that are issued in this case.
Okay.
Okay, Your Honor, that I can submit to you. So you understand there's no issue about billing. They issued a reasonable charge, we paid 80%.
No, that you
the
get
insurer
there.
goes 20%, period.
Balance.
Down to a half minute, so.
Down to a half minute. This whole idea of win-win-win, you know, the insurer gets reduced copay, which is in so many opinions. It's not a win for requiring an insurance company to pay more than it contracted for. It's not a win requiring an insurance company to pay more than what the statutory scheme requires. That's not a win. That's a loss for the insurance company. We have a contract here between contracting parties. When a reasonable charge is issued, the insurance company pays 80% and the insurer pays 20%. Period. End of conversation. That's the contract. That's the statutory scheme. I mean, quickly throw
You're out of time. You use that 20 seconds quickly.
I mean, then just say we ask that you reverse the.
Well, you both did a great job. I got to compliment you on that.
Thank you.
Thank you. Safe journeys. We'll be in recess.
Appreciate it. Thank you.
All rise.
Yes, sir.